हेलो एवरीबॉडी, आज हम फंडामेंटल राइट्स के बारे में बात करेंगे। सो देयर आर 7 ग्रुप्स और वी कैन से 7 फंडामेंटल राइट्स रिकॉग्नाइज्ड बाय इंडियन कॉन्स्टिट्यूशंस। दीज आर राइट टू इक्वलिटी जो आर्टिकल 14 से 18 तक है, देन फ्रीडम, राइट टू फ्रीडम जो 19 से 22, राइट अगेंस्ट एक्सप्लॉयटेशन 23 से 24, देन फ्रीडम ऑफ रिलीजन 25 से 28 तक, देन कल्चरल एजुकेशन राइट्स हैं जो 29 से 30 तक हैं, देन राइट टू कॉन्स्टिट्यूशनल रेमेडीज़ हैं जो 32 से 35 तक हैं, राइट टू लाइफ ये जो है ह्यूमन डिग्निटी के साथ राइट जो दिया जाता है, राइट टू लिव विद ह्यूमन डिग्निटी। सो हम इनके बारे में अभी बारी बारी करके बात करेंगे। अब आर्टिकल 14 के बारे में हम बात करते हैं। द स्टेट शैल नॉट डिनाई टू एनी पर्सन इक्वलिटी बिफोर द लॉ। जो लॉ है सबके लिए बराबर है। इसमें सिर्फ एक्सेप्शंस जो आती हैं वो आती हैं प्रेसिडेंट की, गवर्नर की, फॉरेन सोवरन एंड एम्बेसडर्स की। जो प्रेसिडेंट एंड गवर्नर हैं उनके खिलाफ कोई भी क्रिमिनल प्रोसीडिंग हम दायर नहीं कर सकते हैं, लेकिन जो सिविल प्रोसीडिंग है वो आफ्टर 2 मंथ्स के नोटिस के हम दायर कर सकते हैं। आर्टिकल 15 बताता है हमें कि हम रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ के रिगार्डिंग जो है हम डिस्क्रिमिनेशन नहीं कर सकते हैं। इसमें जो एक्सेप्शंस आती हैं वो आती हैं हमारी बैकवर्ड क्लासेस की, SC, STs, वुमेन और चाइल्ड। इनके वेलफेयर के लिए हम कोई भी प्रोग्राम बना सकते हैं जिसमें डिस्क्रिमिनेशन दिखती हो, लेकिन उसको डिस्क्रिमिनेशन माना नहीं जाएगा। आर्टिकल 16 बात करता है इक्वलिटी ऑफ अपॉर्चुनिटी इन मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट। सपोज somebody is from a different state and he wants to get employment in some other state, so there cannot be any discrimination against it. Exception of it is only Jammu and Kashmir, where only the residents of Jammu and Kashmir can apply for the jobs in JNK. Now in Article 17 we are talking about abolition of untouchability. So there were various acts, and then and after that they are modified. Now the act is Civil Rights Protection Act 1976. There are two important things which you have to keep in mind, that a person which is convicted for the offence of untouchability is disqualified for the election to any legislator. And second thing, the punishment is of the range of 2 years, up to from 1 to 2 years of imprisonment is there. Some part of it also comes under section 15(2), which says that you cannot deny any person access to shops, public restaurants, public entertainment, use of well tanks, etc., maintained wholly or partly out of state fund or dedicated to the use of general public. So I think it is clear that about an untouchability thing. One interesting thing is that in Constitution, untouchability is not defined. But however, judiciary has defined it, that it clearly means any social practice among the Hindus which looks down upon a certain class of people on account of their birth and makes a discrimination against them on this ground. Abolition of titles means the government cannot confer titles to any national, because that was being misused by British when there was British rule in India. That was being misused by British for corrupting public life for imperialistic purposes. So the Constitution seeks to prevent such abuse by prohibiting the state from conferring any title at all. Now, the interesting things about that, the ban operates only against the state. It does not prevent any other public institution, such as universities, to confer title. Now, state is not debarred from awarding military or academic distinctions, and state is not prevented from conferring any distinction or award for social service, which cannot be used as titles such as Bharat Ratna, Padma Vibhushan. And thus this titles, which like titles, there is evolution of titles. Thus Bharat Ratna, Padma Vibhushan are mere decorations and cannot be used as titles. In 1977, the Bharat Ratna award was stopped by Janta government, but it was restored by Mrs. Gandhi after her comeback. So one question I think will come in your mind, that why Padma Vibhushan and all Bharat Ratnas are exceptions to that, because as per Supreme Court, these are not the titles of nobility and hence do not violate Article 14 or 18, provided that they are not used as titles or prefixes or suffixes to the name of the awardee. This Padma Shri Bharat Ratna can be given for advancement in art, literature, and science, advancement of art, literature, and science, and in recognition of public service of higher order. The others can be awarded for distinguishing public service in any field, including service rendered by government servants in order of the degree of the merit of their service. Now, Article 90 talks about the rights which all the citizens have regarding the freedom of speech and expression, to assemble peacefully and without arms, like Anazara is doing right now, then to form association or union or cooperative societies like NGOs, etc., for the welfare of the people. Then all the citizens have the right to move freely throughout the territory of the India. Like we can go to Jammu and Kashmir, to Rajasthan. Nobody is there to stop us. That why you are moving around there, around here. Sorry, to reside and settle in any part of the territory of India, and to practice any profession or to carry on any occupation, trade, or business. In there is interesting thing to note that in Article 19F, that is regarding the property, is being omitted by this Article 19F regarding the right to property was omitted by by Amendment 44. The unions of officers or police officers, the Parliament can make amendments in the rights of the unions, and in the interest of sovereignty and integrity of India, the security of the state, friendly relation with foreign states, public order, decency, morality, or in relation contempt to court, defamation, or incitement to an offence, the reasonable restrictions can be exercised by the government. Now, Article 20 talks about the protection in respect of conviction of offences. For this, if anybody has done against anything against the law, then only it can be convicted in that case. Otherwise, he cannot. And second thing which you have to keep in mind is the convict should not be given penalty greater than which might have been inflicted under law in force or effect at the time of the commission of the offence. लाइक उसमें अगर कोई ऐसा काम किया है जिसके लिए उसको 2 साल की जेल होनी चाहिए, लेकिन उसको 5 साल की हो गई है, तो ये जो है इसकी प्रोटेक्शन उसको अवेलेबल है आर्टिकल 20 के तहत, वो दायर कर सकता है मुकदमा. And no person can be prosecuted and punished for the same offense more than once. मतलब एक बारी हमने चोरी कर ली है, उसके बाद बार बार हमको उसी के लिए हमें सज़ा दी जा रही है, तो इसकी प्रोटेक्शन हमें कॉन्स्टिट्यूशन अवेलेबल है. The one thing I forget to mention in Article 20, that is a person accused, there is immunity for the accused from being compelled to give evidence against himself. The court cannot compel, or anyone cannot compel the accused to give evidence against himself only. Now, in Article 21, Article 21 talks about the protection of life and personal liberty. Here, no person can be deprived of his liberty except according to law. For this, there are certain specific safeguards against arbitrary arrest or detention. So, a person who has not done anything wrong cannot be sent to jail. uh, he have the protection under Article 21. This Article 21 is also known as freedom of a person. Now, Article 21A. This is included in the Constitution by 86th Amendment Act in the year 2002. This has made a right of education as a fundamental right. There is one more thing in Article 21 that needs to be considered, that the Parliament can make laws to restrict the freedom of a person. But Supreme Court has said in Menka versus Union of India case that this deprivation, such deprivation must not be arbitrary, unfair, or unreasonable. So this is open for judicial review. Then this includes Article 21 includes right to life also, but right of life does not give you right of death. That if you are convicted in a suicide case, you are about to be given imprisonment, and khap panchayats that give dictates of honor killing, and these are wholly illegal and has to be ruthlessly stamped out. Then in case of custodial deaths, there are many cases in India regarding that. These are one of the most worst crimes. Any form of torture, cruel, inhuman, or degrading treatment would fall within the inhibition of Article 21. Now, Article 22 talks about protection against arrest and detention in certain cases. Certain cases here means preventive detention. What is preventive detention? Preventive detention is a detention which is done to a person to prevent it from doing something wrong. In case of preventive detention, the government is entitled to detain such person in custody only for 3 months. And for if more than 3 months is required, then they must obtain a report from an advisory board who will examine the papers submitted by the government and also by the accused as to whether the detention is justified or not. Now, the person so detained shall be informed of the ground of his detention, except facts which the detaining authority consider to be against the public interest to disclosure. So, so the detaining authority, if think fit, then the detainee can be supplied the copies of all documents regarding the case. The person detained has the earliest opportunity of making a representation against the order of detention. So one more thing which I want to clear here is that there is difference between preventive detention and punitive detention. Preventive detention is done to prevent the person from doing something wrong, and punitive detention is done to punish the person for what he had done wrong. So right against exploitation. This article 23 talks about right against exploitation, like exploitations of weaker section of the society, then of children trafficking, or human trafficking, or forced labor, or slavery. There is prohibition regarding these acts, and the Constitution provides us remedies. Now, Article 24 talks about child labor, and there is a law, Child Labor Prohibition and Regulation Act. All the employers of the children below 14 years must comply with the provision of this act, and this act provide for compensation, employment of their parents, guardians, and their education. This act specify that no child below the age of 14 years shall be employed to work in any factory or mine, or engaged in any other hazardous employment. Now, Article 25 talks about freedom of concise and profession, practice, and propagation. Freedom of concise. What is freedom of concise? Freedom of concise is your belief in God, how you relate to God. Like there are many ways, Nirgun Nirakar and Sargun Sakar, or even in Buddhism and Jainism, they do not believe in God. So there is freedom of conscience in our constitution. Everyone can think of its relation to God or to happiness. Now, when it is freedom of conscience is done practically, it is known as profession, practice, and propagation. Now, as a profession, there is the freedom to think of a religion as a profession, then to practice a religion, then in propagation there is one issue which is coming today, like Ghar Vapsi movement in south and in north also in some parts. Now, Ghar Vapsi movement, as per Article 25(1), nobody, anybody can can with his own consent can convert to any other religion. But if there is any fraud or any allurement, force or inducement, it takes away this freedom of consent from the would-be convert. If anything is done like that, the state has the right and duty to intervene. Okay, so state has the right and duty to intervene if such activity or conversation offended against public order, morality, or health. So this you can write if any questions comes regarding Ghar Vapsi or illegal conversion of person from one religion to another. Also, there is international convention regarding that. International Covenant on Civil and Political Rights 1966 says that no one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. Article 25. Now, Article 25 is complete. Now, here it comes the Article 26. The Article 26 talks about freedom to manage religious affairs. By religious affairs, we are by manage of religious affairs, we are talking about establish and maintaining of institutions and its matters of religion, and own and acquire of movable immutable property of religious institutions, then to administer such property in accordance with law. In accordance with law is means that these are subject to public order, morality, and health. 27 has come. Article 21, 27, sorry, Article 27 tell us that there is freedom as to payment of taxes for promotion of any particular religion. And why is that so? Because India is a secular country. As per Article 28, there is freedom as to attend at religious instruction or religious worship in certain educational institutions. That this means that there no religious instruction shall be provided in any educational institution wholly provided by state funds. Like if some institution is getting funding from the states, wholly funding from the states, then no religious instruction shall be provided in that particular institution. Or there can be institutions where there can be institutions where which are established as per endowment of the trust, as the endowment of the trust, like, which requires that religious instruction shall be imparted in such institutions. Even though religious instructions can be imparted, that means religious instruction can be imparted in educational institutions recognized by or receiving aid from the state. But no person attending such institution shall be compelled to receive that religious instructions without the consent of himself or his guardian. Also, there are restrictions to that also that imposed by states. The restriction imposed by states in interest of public order, morality, and health. Article 29 talks about protection of interest of minorities. A minority community is one which is minority in population, which have minority in population. Now, Article 29(1) guarantees to every section of the citizens residing in any part of the India having a distinct language, script, or culture of its own, This is also a definition of minority: distinct language, script, or culture of its own. The right to conserve the same. Like a minority community can preserve its language, script, or culture by and through educational institutions, for example. Yes. Now, this right is also guaranteed to them by Article 31 and 32. Sorry, 30 subpart 1 and 30 subpart 2, not 31 and 32. Now, also the minorities cannot be denied admission to any educational institutions receiving aid out of states or maintained by the state on the grounds only on religion, race, caste, language, or any of them. This is what I talked about in Article 29. There is a right of minority to establish and admission educational institutions. Article 31A. It relates to the a law for the acquisition by the state of any state of or other intermediate interest in land. What was the object of taking out this article by 44th Amendment? It was to make it possible for the government to effect agrarian reforms, which are urgently needed to protect the interest of tenants as well as to improve the agricultural wealth of the country. And now Article 31, this article has been taken out of Part 3rd, that is fundamental rights, and made a separate article, that is Article 300A, which reads that no person shall be deprived of his property save by authority of law. So what is the difference now? It has been shifted to 300A and taken out from Part 3rd. Now this means that if an individual's property is taken away by a public official without legal authority or in excess of power conferred by the law in this behalf, he can no longer have speedy remedy direct from the Supreme Court under Article 32, which we will read in some other presentation. That Supreme Court under Article 32, because the right under Article 300A is not a fundamental right. If it is a fundamental right, then only he can go into Supreme Court directly under Article 32. If, but now what he will do? He shall have to find his remedy from the High Court under Article 226 or by an ordinary suit, because this does not come under fundamental right, and Supreme Court only take cases under Article 32 that are that are related to fundamental rights only. Article 32. Article 32 talks about remedies for enforcement of rights conferred by this part, means fundamental rights. So it guarantees to individual the right to move to the Supreme Court by appropriate proceeding for the enforcement of fundamental rights covered under Part 3rd of the Constitution. This this right is remedial in nature. This is also a fundamental right to move to Supreme Court, but this right is remedial in nature. It is this remedial right, this Article 32, which makes the other fundamental rights real and meaningful. If there is no remedy, because if there is no remedy, there is no right at all. It is the guaranteed remedy. It is the guaranteed remedy which provides teeth to all the fundamental rights. That is why Article 32 itself has been incorporated as a fundamental right in the Constitution. Dr. B.R. Ambedkar says that Article 32 is the most important of all the articles, and an article without which the Constitution would be a nullity. So in subpart the Supreme Court and Article 32 subpart 2, the Supreme Court is endowed with the power to issue directions or orders or writs, including writs that are habeas corpus, mandamus, prohibition, certiorari, and quo warranto, whichever is appropriate for the enforcement of any of the rights conferred by Part 3rd or fundamental rights of the Constitution. So first of the writ is habeas corpus. It means it is the nature of an order calling upon the person who has detained another to produce the letter before the court. The writ may be addressed to any person, whatever an official or a private person. So this petition becomes infructuous if the detainee is produced before the magistrate. However, there is exception to habeas corpus that it cannot be issued in the cases where the person against whom the writ is issued or the person who is detained is not within the jurisdiction of the court. And second thing, to secure the release of a person who has been imprisoned by a court of law on a criminal charge. Then the third and the final thing is to interfere with the proceeding of a contempt by a court of record or by parliament. So these are the exceptions to habeas corpus. Now, the second writ is of mandamus. Mandamus, it is both for judicial and administration. So it demands some activity on the part of body or person to whom it is addressed. And also, whenever a public officer or a government has done some act which violates the fundamental rights of a person, the court would issue a writ of mandamus that is restraining the public officer or the government from enforcing that order or doing that act against the person whose fundamental right has been infringed. Apart from the enforcement of fundamental rights, mandamus is available from a high court for various other purposes, like to enforce the performance of a statutory duty, and to compel a court or judicial tribunal to exercise its jurisdiction when it has refused to exercise it, to direct a public official or government not to enforce a law which is unconstitutional, and to compel a person to perform his public duty where the duty is imposed by the constitution or statute. But mandamus, there are exceptions on also, and mandamus that it cannot be granted against a president or the governor for the exercise or performance of the powers and duties of his office. And also, it does not lie against a private individual or body, whether incorporated or not, except where the state is in coalition with such private party. If the state is not coalition with such private party, this mandamus cannot be issued to any private party. Now, the third writ is a writ of prohibition. This writ of prohibition is issued by Supreme Court or High Court to any inferior court that forbidding the latter to continue proceeding. Now, this can only be given to judicial or quasi judicial institution. Now, now the next is certiorari. Certiorari is available at the later stage. Like what is later stage? Later stage means when is issued to quash the order or decision of the tribunal. When prohibition is issued to prohibit the tribunal from making the ultra virus order or decision. Like when the order is already made, then certiorari is issued to prohibit that issued order. Now, Q warranto. The Q warranty inquires into legality of the claim that a person as a party assets to a public office and to oust him from its enjoyment if the claim be not well founded. That to what authority you have taken this seat in the public office. If you are not eligible, then why you are taking this seat? So a person can a person can go to a court to issue him a writ regarding that. This writ is known as Q warranto. Article 33. Article 33 talks about parliamentary powers to modify or restrict fundamental rights. The fundamental rights to the members of armed forces, police forces, intelligence organization. Why is done so? Because so as to ensure proper discharge of their duties and maintenance of discipline amongst them. Like uh, restricting the fundamental rights of defense personnel for the sake of discipline, which is absolutely essential to maintain the security of India. So, security of India is the priority of the parliament. So, they can amend it as per that. Like, for example, if I will give you an example that the armed forces are being defense forces The members of defense forces are prohibited to give prayers, to offer prayers during office hours. They cannot do so. So security of India is a priority. So Parliament can make laws regarding that. Also, in case of during the proclamation of emergency, the fundamental rights guaranteed by the Constitution will remain suspended. Like as soon as the proclamation of emergency is made, the state shall be freed from the limitation imposed by Article 19. Citizens shall have no remedy for acts done against him during the period of proclamation in violation of the above rights, like fundamental rights. Here it is necessary to mention Article 359. Now, uh, the further there should be further order by the president, where proclamation of emergency is in operation. The president may, by order, declare that the right to move a court for the enforcement of any of fundamental rights shall remain suspended for the period during which the proclamation remains in force. So there should be an order by the president. And the fundamental rights, including those which are conferred by article other than article 19, with the exception of those conferred by article 20 and 21. So there will be exception of article 20 and 21. Then person, the order of the person, president however shall not be final, and also there is exception of article 20 and 21 in this proclamation of emergency. However, the Article 20 and 21 cannot be suspended by this order under Article 359, which President will be making. Article 34 that I already talked about is restriction or right conferred by this part while martial law is enforced in Indo. Article 358 of proclamation of energy, and Article 359 regarding the order given by the President. Now, Article 35. Article 35 relates to legislation to give effect to provisions of this part. This means that the power to make laws, to give effect to certain provisions in Part 3rd or fundamental right, shall vest only in Parliament and not in state legislation. Like in Punjab, legislators cannot make law regarding fundamental rights, only the Union Parliament can do so. Thank you very much to be with me, and I hope this will be useful for you, and I will welcome your suggestions regarding that. If any other topic you want to learn or you want to know about, so please message me, or you can follow me on my Facebook page. That is Solutions Research, IAS Preparation Online Solutions Research, and feel free to contact me also. Thank you very much.